Bowing to husband's pressure, wife changed her will, even though she thought it was early in their relationship for such a change. She amended her will so that her husband and her children would inherit 80% of her residual interest in her personal wealth. That would make me nervous if somebody I'm marrying is wanting that. I would be concerned that I would have a fatal accident.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen. Here's attorney CPA Joe Cordell.
Welcome to another episode of Life's Third Act. This week we're going to talk about not so much the celebrity and the matter of estate planning, but its impact on the estate of a surviving spouse. So the person we're going to talk about is the surviving spouse of John Belushi, which is Judith Pisano. That was her previous married name. But let's kind of set this up, and then we'll talk a little more about Judith in a few minutes. So John Belushi, as we all know, he is incredible comedian, Saturday Night Live, incredibly successful career, dies at age 33 in 1982. But he had married his high school sweetheart from Chicago in 1976. And her name was Judith, became Judith Belushi, and that's still really primarily how she's known today. So Judith Belushi continued to be very supportive of her husband's career. She herself was involved in the movie or the television industry, kind of on the periphery to a large extent. So she continued to be married to John Belushi until his death, after which she was the surviving spouse, the widow. And it's not surprising to learn that there was a significant amount of value in John Belushi's estate. He had actually prepared a will. He hadn't prepared the sort of trust that we would like to see. Had those trusts been properly prepared, we definitely wouldn't be talking about what is the primary focus of this show today, which is how to hang on to the assets after your loved one has passed away. And let's not forget that the simplest solution to that, to avoid things that might happen later, is to have it in a trust. And this discussion today will show us why this can be so beneficial. In any case, he did have a will to his credit, and he left everything to his surviving spouse. The value of his estate at the time is estimated at $2 to $3 million. He had a substantial life insurance policy of around $1 million. And keep in mind, the value of intellectual property is the primary asset or asset category in the estates of celebrities. And we know that pertains to royalties or residuals from television or movies that people have done. But it also pertains to the brand and the likeness and identity of someone. So somebody who has a real huge persona, as John Belushi certainly did, is going to generate a lot more income after their death than somebody who had a lower profile, did not have fans as fervently devoted or as numerous as John Belushi did. But John Belushi was such a massive character that it was inevitable that he would live on in terms of value of his name and reputation, et cetera. So that was a massive potential stream of income that one could expect in the future. And let's not forget Blues Brothers. Blues Brothers, in addition to stimulating royalties, apart from that it's this brand. And the Blues Brothers turned out to have a huge brand that threw off a lot of money over many years. We don't know how much. That information's not available to us, but we can speculate that it was a substantial amount. I mean, Dan Akroyd also was very involved in maintaining that brand and that image, and in fact worked with Judith, the surviving spouse of Belushi, to protect and enhance that brand so that it would live on as long and as fully as it can. So let's talk a little bit about Judith. I think that many people are unaware of the extent to which, she's a very accomplished person in her own right. And she's to be admired for the role that she's played, especially in preserving the memory of John Belushi, to whom she was very devoted and of whom, she has had, so much to say and so many efforts over the years that doubtlessly without Judith, John Belushi's, it's safe to say, his reputation would probably not be as visible or as intact as it is today. So she was just a massive storm of effort to maintain that. And so a little bit about her. I didn't know as much about her, incidentally, I'll admit, before we did the show. I just wasn't very familiar with her. But she also had small acting roles in National Lampoon's Animal House. I didn't know that. I've seen that a bunch of times. Now I'm going to look for her. And she was also in the Blues Brothers, I think a cocktail waitress. I don't remember that scene either, but I haven't seen that movie in a while. So she was executive producer for the Blues Brothers.
There's a DVD copy right there. So if you need to rewatch.
Blues Brothers. Now, I cannot neglect this. Justin, with heroic efforts and foresight, decided to bring this today so that we would have a prop. We're running low on props on this show. I mean, so low that we haven't had any before.
I think we need to start a new trend.
So, all right, this is our first prop. Make a note of this date, Justin. For those of you born after 1990, this is called a DVD. Some of you may have seen it around your parents' house. In any case, this was such a great movie. Such a great movie. So Judith, continuing on, she was credited as a writer for Saturday Night Live in 1981. After John Belushi's death in 1982, she dedicated, as I indicated, a significant part of her career to preserving his legacy. She managed the John Belushi estate and the official John Belushi Instagram account. Apparently, that is a huge account. How many million subscribers? I guess you have subscribers for Instagram.
Yeah, I unfortunately I can't look that up because I don't have Instagram on my phone, and unless you have an account, you can't look it up.
Okay. So. She was involved in various Blues Brothers related projects. She participated in the creation of the 2020 documentary Belushi. She was tireless in preserving her former husband's memory. And now, having said all these wonderful things about Judith, I have to add this. And this is entirely coincidental. We're not doing this show because we knew she'd recently died. We were doing the show anyway, and we're going to talk about her. And then just as we were assembling the material, we realized that she just recently died. It's common for us to look and see what whoever we're talking about, what are they doing today? And so that led to our trying to locate her and then finding out that she had died about a month ago. She died of endometrial cancer. So, this marvelous woman who did so much to preserve the memory of her husband, John Belushi, she passed away from endometrial cancer. So now that we have this background, let's go ahead and shift gears and talk about Judith after Belushi's death. So Judith meets Victor Pisano. She meets Victor Pisano in about 1987. 3 years later, they are married in 1990. Victor has 3 children from a prior marriage. He has custody of those. So Judith and he continued raising those children together and covering most of their expenses. Judith and Victor, as I mentioned previously, have had one child, and that child's name was Luke. A little bit about Victor's background. He wasn't especially successful, though he aspired to be a producer and a writer. And he had had a few successes. His IMDb account or record shows that there are 3 projects for which he's credited. There are 2 TV shows for which he was a producer, and this was in 1985, and then there was one in 2017. So Internet Movie Database, IMDb, is going to list anything virtually creative relating to movies, television, any sort of video productions that are sold to the public. So IMDb is a wonderful source for knowing the extent to which somebody has been successful in a creative career. And it's interesting that Victor was not, we couldn't find, we found very little. So he wasn't what you would characterize as successful. He tried. He had written, for example, a number of screenplays or plays, and he had trouble selling those. But at least as far as we can find, we can only find these at the time of the marriage, 2 projects that he had done that had actually gone through. And they were both 2 TV shows. One, I think, was a miniseries. So I cannot see where he would have had much income at the time, and the records we're about to go over are going to confirm that. But Judith, of course, was living on the intellectual property income related, of course, to John Belushi. Now, what's interesting leading up to their marriage is that there was discussion about a prenuptial agreement. So a prenuptial agreement is the second best thing. The best thing in a situation like this is, and I repeat myself, is to have a trust for, the person who's planning for with assets for the lives of their children, or in this case, surviving spouse. But this is emphatically even more true for children. But whether it's surviving spouse or children, you have the option to protect them from the risk of largely remarriage. We give lots of other risks, and there are lots in this economy in America. There's the risk of lawsuits around every corner. There's people who can prey on you with business deals, even pretty savvy children. This doesn't assume your children are foolish or naive. It doesn't assume your spouse is foolish or naive. But they can step into a hole. They can meet somebody who presents a deal to them that just was not what it was promised to be. And then, of course, there's things like bankruptcy. Bankruptcy happens, even to people who are smart and talented. I mean, some of our most successful business people in the world went bankrupt at one time. But while they recovered, maybe, keep in mind, most people, statistics show, don't recover from bankruptcy, depending on what point they are in their careers and, of course, who they are. But bankruptcy is a big blow. It's a blow to your future as well as to your present. So anyway, Judith decides to marry Pisano, and they decide to have a prenuptial agreement. It's interesting that Judith was the one who insisted on the prenup. And again, I'm speculating here. I don't want to be too unfair to Victor, but having been a divorce lawyer for a number of decades, I do form, mental pictures based on fact patterns. And those can be wrong, but they are born of experience, and I would say more often than not they're correct. But in any case, we have a guy who's come along. He doesn't have a lot in the way of income. I would argue he doesn't have a lot in the way of potential. He would argue with this, of course. But he marries Judith, and Judith now is in a position where she has an obligation, in effect, to support him and his 3 kids. Now, I'm sure he continued to work. I'm giving him the benefit of doubt. I'm sure he continued to do things to try to earn money. But it was just the fact that Judith was in a position to have a lot more money. She also owned a house in Martha's Vineyard, and that's where they lived primarily. And they ended up acquiring a property at, I think it's called Ford's Plantation in Georgia. And that was a property that they used as their vacation home. So their marriage lasted for a substantial period of time, I should add. Their marriage lasted until from 1990 until 2010. So 20-year marriage is significant given its start. Often marriages like that don't last as long as that. But these parties obviously made a go of it for a long period of time. But clearly, this is a situation where one side of the table is the beneficiary of the passage of time and the other's not. And usually that's the nature of a marital relationship, financially speaking, is that for one party, time is their friend, and for the other party, time is their enemy. So the person who is accumulating benefits, whose life is being generously supported, who may be acquiring stronger claims to more than they would have if the marriage were ended sooner than later, and we'll see some of those claims here in a little bit. It's kind of the effect of many of the challenges to the prenup we're going to talk about. But that person has no incentive to run into a divorce court. In fact, that person has every incentive to drag their feet to try to keep the marriage limping along. And meanwhile, the other party does have this sense of urgency. The sooner they get out, the less it's going to cost them. And that person sometimes just doesn't, have the energy, or maybe they dread just the prospect of going through a divorce, so they tell themselves maybe it'll get better. Meanwhile, you have the person on the other side, what will be on the other side of a table. You have them saying, we can work this out, let's give it another try. You don't want to be the one who ends this marriage. So there's all sorts of games that go on to where what really becomes, pardon the phrase, a zombie marriage can go on for quite a while. But again, keep in mind that circumstance usually benefits one side and not the other. Rarely is it equally beneficial or equally adverse to both sides of the table. Generally, you'll find that there's a substantial disparity between the benefits and the detriments of that decision and the parties. So the way I'm going to do this is I had a few of my attorneys pull some records from Massachusetts where this divorce occurred. They're residents of the state of Massachusetts. Again, I'm not an attorney from I'm not licensed to practice law in Massachusetts. I'm licensed to practice law in Missouri and Illinois. Furthermore, I'll say that I don't currently practice domestic relations. Cordell & Cordell does, and so, yes, I'm sometimes involved with Cordell & Cordell, but we have a wonderful team over there, and we have great partners and a CEO, and so I'm not regularly involved in practicing domestic relations law as much anymore. So it's kind of ironic that I'm doing this show today, and I'm going to be talking, it may seem, a little more about domestic relations or family law than I am about estate planning. The reason I'm doing that is because in this case, they kind of come together. So in order for me to make what I really want to make primarily is the estate planning point, I have to make some points related to domestic relations. And these domestic relations points, incidentally, are relevant, and you should note them. But of course, this show is not devoted to that. So having said that, I had our attorneys pull these documents from the court so I could review them and kind of see what happened in this case. I was very interested in this divorce. And it's funny, when you read the file, you learn so much. There's some things you don't know looking at a court file. And sometimes, incidentally, some documents can be sealed. In this case, I don't know of any that were sealed. But still, the documents don't tell everything, but I would argue that they tell the most important things. And so I went through this last night as I was preparing for this show, and it was very interesting, I have to tell you, the course of this. And I think probably the best way to approach this is for me to kind of walk you through some of the documents, and I'll talk to you as I'm looking at these and fill you in on what these events and facts are and what the issues are. So there was a petition for divorce. It was filed by Judith Belushi Pisano, and the defendant is Victor Pisano. She filed this in, looks like, October of 2010. And, this was a notice of appeal. So the petition for divorce was filed in 2009, and at this point, the case was bifurcated at the request of the petitioner. And here's what I mean by bifurcated. Sometimes you'll have issues in a divorce where either party can petition the court to break it into pieces and deal with one piece first. And often that's attractive, where that one piece is going to resolve probably the other pieces, or will give the court direction as to how to resolve the other pieces. So I'll go to the primary issue in this divorce. The primary issue related to this prenuptial agreement that was signed in 1990. So at the time, though both parties had counsel, though they both signed it, now again, there's the incentive for one party to try to undo it and another party to preserve it. And as you might predict, that is the thing that you can expect anytime you're doing a prenuptial agreement. And the thing that I said about the nature of time applies to this as well, in that there's a disparity. So the extent to which one party should have a prenuptial agreement is probably going to be counterbalanced by the other party having a disincentive to want to do that. Occasionally, though, you'll have scales balance on this. I should add that sometimes you'll have an older couple where, they're 50 years old and they've each accumulated estates and they have children. Each of them have children. So the children are saying to their mom or dad, look, when you marry, you should think about having this in place. So, and that's a fair message. And in that case, both sides of the table have an incentive to be able to put in place something that will protect their children, their families, their future. So it's not uncommon for you to have both sides equally motivated to have a prenup. But at younger ages, especially when there's a disparity in age, typically there's also a disparity in the incentives to have the prenup. Generally, one side really wants it, and the other side either really doesn't want it, or is very reluctant but can be drug along. And this was the latter case, in my opinion. I think Victor was drug along. So as we'll see as we go through these documents, he participated as little as he could and obstructed where he could, it appears. And as a result, when the divorce comes along, here we are 20 years later, you can expect him to challenge the prenuptial agreement. So anyway, so the case, once the plaintiff, which is Judith, realizes that this is going to be challenged, she asked that the court bifurcate the case and bifurcate the issues and make a declaration or a finding. Is this agreement valid? Because if it is, it resolves a bunch of questions in this case about how property and maintenance and other things are handled. Or is it not a valid agreement? Now, naturally, she expected the court to affirm, yes, this is a valid agreement. And then of course, the way things will flow in the divorce will be much simpler after that. I should mention here that Luke is of an age, so there's no child support dispute or custody dispute. This is really all about property. So I'm going to go through a good summary here by the trial court of what's going on in this case. I can't do any better. So I'll read. I won't just read this to you. I'll read it to you and I'll make comments as we go along. But I think that this is the most interesting way to do this. The parties were married October 7th, 1990, Martha's Vineyard. Probably was a very elegant affair. And October 20th, 2010, the wife filed a complaint for divorce. She asked that these issues be bifurcated, which I've just explained. There was an issue about temporary support where the husband asked to have her be ordered to pay for support while the case is pending, to pay for all the costs associated with their two pieces of real estate I mentioned, to make all education payments relative to the party's son, Lucas. I think he was in college at the time. To maintain health insurance for the benefit of the parties and their son, to pay reasonable uninsured medical expenses, and to pay the husband $2,000 a month in temporary alimony. Now, this is a temporary order, so this is just while the case is pending. So it's not subject to the same rules necessarily that the prenup would govern in the final order. So findings of fact. This is a second marriage for both parties. The husband has 3 children from his prior marriage, 3, and who lived with husband and wife, which means wife is supporting them largely, for many years. And they were supported by the wife during most of the time of the party's marriage. Now, these are all findings by the court. This is the judge's findings after listening to the evidence presented at the trial regarding this prenup by both sides and their witnesses. There's 1 child born of the marriage. Lucas, we talked about him. Wife had valuable real estate located on Martha's Vineyard. This was at the time they're married. It was her primary residence. And she also had another property there as well, or nearby at Chilmark. Her income was primarily from royalties and residuals from the intellectual property. Prior to August 20th, the husband was a writer, producer, documentary filmmaker. I kind of gave you an answer as to how substantial that was, but it certainly sounds good. But the court is making a point here that he negotiated various business transactions regarding production, residual rights, intellectual property, and royalty payments for himself and to his company, which he had a company called Night Owl Productions. So the court, when it makes this point, is telling you that this is not somebody who doesn't have any experience with this subject matter. And he ran a company, his own company, and he negotiated these things because he did have some things that were in fact produced and aired. So the husband and wife testified that they had discussed a prenuptial agreement as early as the holiday season of 1988. Judith made it very clear that, wife-to-be, had made it very clear that she wanted to have something in place to protect what she had. She was a savvy person who, I think her instincts were good. I think she had some reservations here, and she wanted to do this. The husband agreed, so he said. Prior to August 1990, the wife had been an author. She'd written a book related to John Belushi. She was a writer, a graphic designer, a producer, and a speaker. So she was a person who was engaged in commerce. She was engaged in the world. She had the ability to speak in public. So, she became this advocate we described earlier for the career of her ex-husband, deceased husband. Let's see. So during his first divorce, you should know this, that Victor had been represented by his friend, Anthony J. McNulty. Hereinafter, he'll just be called McNulty. So this is important because of a claim that Victor's going to make later that this person had been simply a friend of his and that he hadn't really represented him in this prenuptial agreement, negotiations, et cetera. So that's the reason this is mentioned. So his attorney in his prior divorce had been this McNulty. Between Christmas of 88 and August of 90, so this is a good chunk of time, Christmas of 88, August of 90, husband and wife had several conversations about what the terms would be that they would have included in a prenuptial agreement as they anticipated their marriage. Sometime between December 88 and August 90, husband had consulted with his former attorney and friend, McNulty, and they discussed the concept of a prenup, et cetera. So husband lived with the wife at this 112 William Street property, which is in Martha's Vineyard, for about 3 years prior to the marriage. And he was well aware of the real estate holdings of the wife at the time of the marriage. In fact, Judith was having some financial challenges at the time. We don't know exactly what all those involved, but it probably involved some disputes with vendors who might have been using John Belushi's name. It could have been a dispute about a split of royalty interests, maybe with a record company for like the Blues Brothers, or we don't know. But there are lots of things where it could have been where she was going through some financial challenges at the time. And the court, everything I'm mentioning to you here are findings by the court. The court chose to put these things in its order, which means the judge thinks that they were important to his or her decision. So in this case, on or about 1989, he requested and the wife granted the right for him to have direct communication with her business manager. So he wanted to deal directly with her business manager. And then from time to time, he reviewed the wife's monthly asset and liability statements that she received from her business manager. So he was reviewing the documents. This is important because one of the things that will always be a center point of attention relating to a prenuptial agreement is whether the other party who's opposing it was sophisticated. Did they understand the number one things of the world? Did they understand about business enough to comprehend the deal, or were they taken advantage of? Were they also aware of what the assets were of the person that they're doing this deal with. And that's always critical. Anytime you have a prenup, and one of the most important things you can do is each side to exchange financial statements. If you're the one wanting the prenup, you want to thrust on the other side full disclosure about all of your assets and liabilities. Don't hide them. Your instincts may be, well, I don't want to disclose any more than I have to. I just want them to sign this agreement that everybody keeps what is theirs. It's a bad idea. Meaning one of the cornerstones to success with a prenup when it's challenged at some point down the road in a divorce is that there was full and total disclosure. That's what hoists by the petard the other side of the table, because they're going to say, I don't want to do this, it's not fair. And the court's going to say, but you knew about everything. It was all disclosed to you. And that means there have to be attached to the document itself financial statements that are really comprehensive. It's just one of the essential elements to doing a prenup. So in this case, not only was it attached to the document and fully disclosed, handed over prior to signing, but the guy was living with her and to some extent managing her assets. So this is going to seem really ironic to you in a few minutes when you see his position. But so from time to time, he reviewed her monthly asset liability. He talked with the business manager. In effect, the judge says he had abundant knowledge of the wife's net worth. As a result of those difficulties, he was aware that she wanted to protect the likeness, image, and name of her late husband, John Belushi, and its income-making potential. This is the court talking. So it was clear to this guy what she wanted to accomplish with this agreement. In March 1990, wife requested that her sister's name, Judith's sister's name's Jacklin. And Jacklin is a lawyer and apparently a Massachusetts lawyer, but she's not a divorce lawyer. So she had a colleague, a person by the name of Muehlek, Muehleck, I'll say Muehlek. Muehlek, who in effect became the Judith's attorney. So Muehlek negotiated with McNulty, who is the attorney representing the husband, or Victor, husband-to-be. On or about May 21st, 1990, Muehlek and McNulty spoke. So pay attention to these dates. May 21st, 1990. They're going to get married in October 1990. Both parties had changed their wills prior to the marriage. It's this is the judge's finding here. So that's the reason I want to read it, to make the point of the tone. Bowing to husband's pressure, wife changed her will, even though she thought it was early in their relationship for such a change. So the change that she made, again, bowing to his will, was that she amended her will so that her husband and her children would inherit 80% of her residual interest in her personal wealth. That would make me nervous if somebody I'm marrying is wanting that. That I would be concerned that I would have a fatal accident. But in any case, this is something you see in a movie where it soon becomes, it's a crime detective movie. So the wife reluctantly did that. She changed it back later, though. You'll be happy to hear. But these are the sorts of things. When you watch this show, you do have to endure sometimes my repeating some things. But I really want to strike home to you that this she could very well have not changed it back. This situation could have ended very differently. And why did that happen? Because all these assets and this income was placed in her hands. And she fell victim to this guy. I don't know Victor, so I'm trying to choose my words carefully here. And I'm speculating about his motives till I'm a lawyer. But the point is, she meets this guy, and this could have gone very differently. But the best thing to have done would have been for John Belushi to have had around him somebody who would say, create a trust. Now, John Belushi didn't expect to die of a drug overdose at age 33. So in fairness, maybe he would have done that, or better still, there would have been people around him who would have felt the urgency to do something like that when he's around 35 or 40 or something. But the bottom line is that would have made all this very different, very different. But in any case, So bowing to husband's pressure. It's interesting when a judge chooses words like that in their statement of facts, a statement of findings of fact and law. So again, the good news is that she did change it back so that she was so aware of this issue later on that she changed it to where her husband and his children they were able to inherit 80%, I think, of her estate, but it excluded anything relating to Belushi's intellectual property. So it excluded all the intellectual property, which went to her family. But as to what was left, she was willing to give to her surviving spouse and children, 80% or so of those assets. So I think that was a very reasonable thing to do, a very fair thing to do. So she did adjust that pretty quickly. But note this, however, the husband was not to be a trustee or fiduciary for any of these interests. That was the amended will that was executed in May of 1990. So it seems very early on she knew she had some doubts. Whenever your new husband, you don't even want them to be an administrator or to be a trustee regarding a trust, for example. It's one thing to make them a beneficiary, but a trustee is kind of a guarded role. You have lots of oversight typically, not always, but you have grave consequences if you step out of your role or you do anything at all self-interested. So I'm not suggesting that you can put somebody in a role of a trustee that you have reservations about. No, you should be completely confident in the integrity of somebody that you put in this role. But I am saying that it would have been less risky than simply handing him everything for himself. But she didn't want him to play any role. And this was before they got married. So it tells me she had some reservations. Remember, they had lived together for 3 years. So she probably knew this guy pretty well. We'll never know all of her thoughts in making the decision to marry. I assume this guy really pushed for it. I'm guessing that he pressed all the right buttons, that he knew her well enough to lure her into this marriage. So as part of the consideration for the prenuptial agreement, this is the judge's finding, upon marriage, the wife would transfer a 1/2 interest in her primary residence in Martha's Vineyard. And they'd hold that as tenants in common in consideration for $1. And this was on October 7th, 1990. So you're probably saying, what on earth? Why would she give him a half interest in her marital home, in the home that she had with Belushi and had for a number of years? And this is an example of how there was good planning for her in the prenup. There are some things that we'll see as we talk about this prenup. It could have been done better. For example, they should have gotten it executed sooner. More about that in a second. But it's interesting how she knew that to bolster this agreement, to maximize the probability that it's going to be enforced as written, she wants to go ahead and give him something that shows her good faith at the time this is signed. And that really is the critical moment in evaluating the enforceability of a prenup was it fair and reasonable at the time it was signed, as opposed to 20 years later when you read it and say, for example, the parties are to divide their assets 50-50, or the parties are more likely one party is to get all the assets in his name, the other party is to get all in her name. And if the court simply looked at, is it fair at that time, then imagine the guy, let's assume, has become even wealthier if he was at the time, and then maybe this other person not at all. So at the time that they're in court in front of a judge asking to enforce a prenup, it could be like this in terms of assets. So the last thing in the world, it would defeat the purpose of a prenup if the court looked at whether it's fair at the time they're in court, at the time of a divorce, decades later. So obviously you want, and the law is such in every state that I know of, that the critical date is to look at it at the moment that the parties sign it. Was it fair at that time? So you may have somebody walking into a marriage, they have nothing. You have somebody who has a lot of assets, we'll say. So what are the terms of the deal? Well, it isn't unfair at that time for it to say that any money generated from my assets that will be my money. Any money from yours will be yours. Any assets that I acquire in my name will continue to be mine. Yours will be yours. When you look at it at that date, there's nothing unfair because, the person coming into the marriage that has no assets, they're no worse off, except now they're going to live a much better life, as in this marriage at least. So when you look at it at that date, you think this isn't unfair. So the good news is that that's the way courts look at it. But still, if you want to bolster it further, you can throw in an asset and say, look, if we get divorced, I'm going to give you half of the value of this house. And in this case, she went ahead and gave it to him at the outset of the marriage, which is even better because it makes clear that she's fair and reasonable. She did full disclosure of everything. She had good lawyers, I'll tell you. She did full disclosure of everything. And on top of that, she makes this gesture that you may think, wow, that's a big amount of money. Actually, I don't think it was at the time. There was debt on the property. So I think there was about $300,000 equity at the time. So $150,000, essentially what she would have given this person. So by putting Victor on, he got half of the equity. So yeah, if that equity grows, then his interest would grow. But still, it was a good thing to do. And when I was doing these, I would emphasize things to where you really lock it down. You keep your eye on the big picture. The big picture is this massive, in this case, is this massive amount of money that over the next decades that the Belushi brand will generate and royalties. And I wouldn't get caught up in trying to be too fastidious about everything I'm entitled to when I create this document. When you create the document, you want it to be powerful. And I think that it was expressed very well. And the parties, another thing that you'll see here, as a matter of fact, we're going to it, is, the discussion about these dates. One thing you really want to do when you have a prenuptial agreement is try to assure that it's not signed in the last days, or heaven forbid, the day of the wedding. Those cases are legion out there where somebody put one party put the other in a position implicitly of coercion or duress just by circumstances. And there are even a number of cases where somebody become engaged and the invitations have been sent out, and then one party will say to the other, I want a prenup and I want it signed or we're calling this wedding off. There are cases that have held those prenups to be invalid when they were challenged years down the road because there was no free will effectively for the party to agree to it or not. Under those circumstances, it was argued. Now, you could say, well, they did have free will. They could be willing to cancel the wedding. And some courts, incidentally, would agree with you, but there were some that wouldn't agree with you. So it's a risky thing to do. Fortunately, in the state of Massachusetts, there's actually case law that says that, look, when you sign this agreement, I don't care if you sign it on the day of the wedding. If there's no duress other than that, if there's no other indicia of some sort of overreaching, then we're going to uphold it. So Massachusetts is pretty firm on this issue. So they don't cut as much slack to a party who might be in a position near a wedding to feel obliged. But in any case, to the credit of Judith's lawyers, they recognize that we don't want to invite this challenge. There's always a judge that might say there was a loss of free will here. There was an overreaching. There was implicit duress. So they tried to get this signed as early as they could. And this is where we're going to start talking about a timeline. And remember, we can be sure this timeline is important because I'm reading the judge's statement of facts and findings and conclusions of law. So we're going to break this into two parts. There's a lot of meat in this as we talk about the prenuptial agreement and then later the divorce. So there's a lot of stuff here, and we hope you come back for part 2. See you then.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by Tucker Allen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.